I'm Drew Stevenson, and this is a quick introductory explainer or lecture about acting directors in federal agencies. This is for my administrative law class, but others may find this interesting because it's a subset of the larger body of law that we have on presidential appointment powers. And so just to make sure that we're clear, we have a clause of the Constitution about the president appointing people. Normally, presidential appointments go through Senate confirmation, not House confirmation. And if there's no problem, that's great. And that's our normal setup. Sometimes, though, we have problems. And sometimes we're talking about the head of an agency, a vacancy opening up that needs to be filled right away. So let's go back to our slides. So when we talk about an acting director, we mean that a top position in a government agency has become vacant, and then the president appoints an acting director, or maybe someone becomes the acting director automatically, to fill the spot temporarily until a permanent appointee can go through vetting and Senate confirmation. So if sometimes we're going to know well in advance that a vacancy is opening up or someone is leaving, right? So they tell the president in June that they're leaving at the end of the year, or it's on one of these boards or commissions and they have set terms of years and their term is coming up or is ending. But sometimes these are unexpected and can leave the administration scrambling to find a replacement. And there's a question about whether they have time to vet someone thoroughly, and also a question about whether they will be able to get Senate confirmation. If the Senate is not the same party as the president, and the president has kind of an unfriendly Senate, the Senate can thwart confirmation. And so sometimes the president could have a problem with Senate confirmation. It might be a long, protracted process, or it might take, if we have a difficult Senate, it might take longer to find someone that will be acceptable or will get through the confirmation process. And acting directors are going to serve in the meantime. Now, we have a statute, a federal law that sets some rules about these acting directors. And this is the Federal Vacancies Reform Act. The Federal Vacancies Reform Act imposes some rules about who the president may appoint as an acting director and how long they can serve in this position. It's not permanent. Other laws may also apply and or supersede the Federal Vacancies Reform Act. So Congress can, in other statutes, say that for this agency, acting directors will be chosen this way instead of the way provided for in the Federal Vacancies Reform Act. So sometimes we have conflicting statutes and courts have to sort that out. Now, also note that there are some similarities and differences with recess appointments. So a recess appointment is an appointment that the president makes while Congress is on recess. And this is similar to the acting director in that this is a person who's not going through Senate confirmation. And in fact, both acting directors and recess appointments are sometimes used to circumvent Senate confirmation if there's a lot of tension between the president and the Senate because they're from different political parties. Also, keep in mind the House of Representatives, which is not involved in the confirmation process, can do some scheduling maneuvers to interfere with the Senate's schedule that in turn can make it difficult to do recess appointments. So if the president wants to do a recess appointment, well, a recess appointee is going to stay until the end of the next session of Congress, which could be up to 2 years. Someone who's an acting director has to leave after 210 days. In theory, there's some complicated exceptions, but this means a recess appointment may actually last twice as long in office as an acting director. On the other hand, the president might not be able to make a recess appointment if Congress doesn't go on recess. And so the Senate, or Congress generally, has the power it can thwart the president's ability to make recess appointments by not going on recess. And so this can get very difficult. And we, again, have had some litigation about that's gone to the US Supreme Court about how long of a recess is long enough and so forth. So keep that in mind. Now, what happens when we do have an acting director? Well, the acting director normally will have the same legal authority as a regular director of an agency. And so they can take actions as if they were the head. But there's a catch. The acting director knows that they're typically going to be there for less than a year. And so they don't really have time to implement major policy initiatives or to overhaul the policy agenda of the agency or really to do anything that's in theory should be that controversial. And so there's a little bit of the substitute teacher effect, right? That the person is there temporarily. So they're more likely to try to just keep things in a holding pattern for the time being until a regular director can go through the nomination and Senate confirmation process and would be able to serve out their whole term. Next, keep in mind that even though the acting director normally has the legal authority to act on behalf of the agency and to direct the agency, if an individual was ineligible for the position under the Vacancies Reform Act rules, or if they overstay their term of 210 days, they cannot act with legal authority. Now, that doesn't mean that they're going to go to jail or what they're doing is illegal in that type of sense. It means that some of their actions, if they would have to be done by the agency director, will not hold up in court. Splitting hairs here. Some of the routine actions, right, that they may do that anyone else, any other employee would do if they were out sick that day or something like that, they obviously can still do. But if there's certain actions that only the head of the agency could authorize, if the person was not eligible for it, or if they're no longer eligible for the position, then those actions will not be recognized or honored by the courts. In practice, this normally means that targets of compliance orders or enforcement actions can raise the lack of legal authority of the acting director as a defense. That's normally how this issue comes up in the courts, and we get a fair number of cases about this. In theory, someone from the regulated industry could just bring a challenge, initiate a challenge, but typically this is raised as a defense when you have been ordered to do something by an agency, or you're the target of an enforcement action. And so you say, this has no legal authority, right? This is no different than someone who's not even in that office ordering me to do this. Now, we're going to have some separate videos about the kind of constitutional and policy background here, and also some other related statutes. So, but just really quickly, don't forget that this does relate to the Constitution's Appointments Clause, which specifies that the president should nominate and we should have Senate confirmation for the top agency officials. Note that the Appointments Clause also says that kind of mid-level people in the agency, which the Constitution calls inferior officers, can be appointed by the president or might be appointed by other people in the government, like a presidential appointee. We also have some statutes like the Vacancies Reform Act, and I'm going to have a separate video lecture that goes into a little more detail about the specifics of that act and its rules. But we also have something called the Pendleton Act, or the Civil Service Reform Act, that is relevant because it's the body of law that governs the day-to-day workers in the federal bureaucracy or in the agencies. And then keep in mind that this also touches on an issue that there will be yet another video about, which is the spoils system versus having career civil servants or a professional civil service. Okay, that concludes our little lecture explaining acting directors, what they are, and the fact that there is a body of law that sets some rules about who can be appointed and how long they can stay.